A hearing is asking for $25,000 cash bail, stay away, no contact from the victim and witnesses, abide by any restraining order as well, and this is based on the facts of the case and the defendant's record. The facts are on November 3rd, 2010, officers of the Ayer Police Department responded to the area of 20 West Street. Upon arrival, they saw a man, later identified as the defendant before you today, walking away. He was walking very fast, almost at a slow jog away from Officer Cunningham. Sergeant Crumpton, as he exited his vehicle, could hear Mr. Cooper yelling and swearing. Officer Cunningham told Mr. Cooper that he was under arrest. However, while trying to get the handcuffs on the defendant, he kept yelling and swearing at both officers. He was trying to push them back and was resisting them while they were trying to handcuff him. He was also yelling. Officer Cunningham stated he was yelling at a woman in her 50s. He was agitated and was walking in an aggressive manner. His fists were clenched and his shoulders were hunched up. Officer Cunningham observed that his speech was also slurred. He was yelling, "Thanks a lot, Mom," towards his mother, the victim in this case, Ms. Donna Cooper. When the officer told him to be quiet, he told the officer to shut the fuck up and kept telling the officer to shut the fuck up. As he was trying to be handcuffed, he did pull away from the officer, broke away, and started running north. The officer was able to then handcuff him. The officer then spoke to a witness in the case who stated that he was grilling outside when he heard Mr. Cooper and his mother arguing. He saw the defendant grab the victim and push her to the ground. He stated he heard the woman yelling for help and to call 911. Upon hearing this, the male witness then ran inside his house to call 911. After calling 911, he then exited his home and saw the defendant throw the victim and throws a quote, "throw the victim against a fence." He then proceeded to run up to the defendant and tell him to stop pushing his mother. The male witness's girlfriend also saw the defendant running after the victim as she was yelling for help and then push her into a fence. She did hear the mother also yelling for help. Another independent female witness who was in her home heard yelling coming from outside the home. She then saw the defendant throw the victim against the fence. She said she thought the fence was going to break. She also observed the defendant grabbed the mother by the shoulders and was yelling for help. The officers then spoke with the victim, Donna Cooper, who said that she came home and saw the defendant and her son, who started to attack her and throw items around the apartment. She stated at some point he grabbed a knife from the kitchen area and threatened to kill her with it. She stated that she then walked up to the square when the defendant pushed her. When she got up, he pushed her to the ground and grabbed her by the shoulders and threw her into the fence. The mother was upset while speaking with the officers. It should also be noted, Judge, upon going to the booking area, the defendant was being uncooperative. Booking would range from being cooperative then to being upset and angry. The officers stated that his eyes were glassy and bloodshot, and they could detect an odor of alcohol coming from his breath. Judge, turning to the defendant's record, as you can see from the defendant's record, the defendant does have, out of Ayer District Court in August 30th, 2010, a null process assault and battery dangerous weapon charge, to wit, a knife. I can tell you, Judge, I prosecuted that case, and it was the same victim, his mother in that case. The reason why it's null process is that the mother did not return to court on the trial date. You can see from his record in 2007, the defendant also has assault and battery dangerous weapon, to wit, a knife, where he received guilty probation on that case, violated his probation, and then was given 6 months committed. He also has a different charge, a different docket out of Lowell District Court in 2007 for assault and battery dangerous weapon, to wit, a knife, where he was also given guilty probation. He violated that probation and was given 6 months committed. He's also served committed time for attempt to commit a crime. He has served committed time in 2006 for possession of a Class A substance. Also on his record, he has been placed on quash for possession of Class D substance in 2003. However, he was given guilty short committed sentence in that case as well. He also has more committed time sentences dating back to 2003 for knowing, receiving stolen property as well. Judge, based on the facts of the case, this case happening in front of 3 civilian witnesses who all essentially told the officers the same thing, the defendant's demeanor on that day, his aggressive actions, both towards his mother and the officers, are quite concerning. He has already been indicted in this case, so worst comes to worst, he would be likely to see house of correction time in this case if for some reason the indictment did not stand. However, he is looking at this point state prison time. As you can see from his record, Judge, from his record, it appears that he has a pattern of this type of behavior. Many of his convictions for assault and battery, dangerous weapon, 2-wit, and knife. The case that was nail-crossed was similar, 2-wit and knife on his mother. The case in this case is assault and battery, dangerous weapon, 2-wit, and knife. Just this pattern of behavior is concerning based on his record. His history, Judge, I would say in this case, there was indication of alcohol being consumed by the defendant in this case. I do know based on his matters in Lowell, the assault, dangerous weapon, 2-wit, knife, that was dismissed because the victim did not appear. In that case, there was indications of alcohol abuse in that case as well. And based on the facts, the nature of this record, the amount of time he could be facing, the Commonwealth is asking for $25,000 cash bail, stay away, no contact with the victim and witness, and abide by any restraining orders. Thank you.
All right, thank you. Counsel? Good afternoon, Your Honor. May it please Court Attorney Roland Millard for Mr. Cooper. Your Honor, Mr. Cooper is 27 years old. He is ungraduated from high school. From speaking to his mother on the day I was appointed, my understanding is that he reads at the 5th grade level. He works when there is work for an uncle of his, and he lives with his father. Judge, as you are well aware, this is a bail hearing, and bail is not punishment. It's to ensure the presence of the accused at trial. The Commonwealth had an opportunity to have a 58A dangerousness hearing. They forewent that in order to make a bail argument. Bail is to ensure the presence of the accused at trial. It is not punishment. I would submit to you that if you examine his record, which is 7 pages long, if you redact the NPs, the dismissals, the files, he's not guilty, his record is less than a page long. In every one of these instances, from speaking to his mother, from speaking to my client, there's some kind of substance abuse involved here. Primarily vodka. In fact, on the day in question, the reason there's a pronounced odor of alcohol is apparently there was the consumption of 2 pints of vodka. Although there are defaults on his record, they're financial defaults relative to, upon information and belief, this is what I was told, relative to payment of probation, supervision fees, and things of that nature. He does not default his appearance. Bail is to ensure the presence of the accused at trial, and we must examine the least restrictive form to make sure that he does attend. His record is such that he does attend, even when the charges and the crimes are serious. However, he seems to get in trouble with substance abuse. I would submit to the court that since there is no record in an extensive record that he defaults his appearance, I would suggest to the court that he be released on personal recognizance with some sort of mandatory substance testing through probation to make sure that he does not consume alcohol or use non-prescribed medication or other controlled substances. If you look at his record and you speak to his mother, he seems to be able to control himself and comply with what society expects of him when he does not consume controlled substances or alcohol. And he does show up for trial. Therefore, I feel that $25,000 is clearly out of bounds here. He does show up, but he gets into trouble when he drinks. And there are other restrictive measures short of committing him to make sure he does not drink. And I would ask the court to submit that, to place him on bail for personal recognizance with conditions that he not consume alcohol, that he not use any non-prescription medication, and that those conditions be monitored with regular check-ins through the probation department.
Criminal matter, you're ordered held on $10,000 cash, and if you do make the bail, the conditions of your release that you stay away and have no contact with the named victim and any witnesses in the case. And Attorney Millard, what date would you like?
Since he's been indicted, Judge,
Status date
I'm
here?
supposed to be here on the 14th to try a case. Could we have the 14th of December for status? And I'll waive the defendant's appearance since it's just a status date.
Right, his appearance would be waived if in fact arraigned prior to that date.
Could we waive bail warnings as well, please?
Yes.
And if while, actually, we've already advised him to go on the
thank
last
you.
date, but if while on release you commit any new offenses or violate the conditions of your release, you could be